In today's lecture, we would like to discuss another important constitutional provision of India, that is the emergency provision. As in India, the very provision of emergency in Indian constitution was borrowed from the Weimar Constitution of Germany. The very provision we found from Article 352 to Article 360 of the Constitution. So, Article 352 of the Constitution, it deals with national emergency, and regarding proclamation of national emergency, there is the requirement that it must be on the satisfaction of the President of India that the very security of India is threatened either by war or external aggression or armed rebellion. The very provision of armed rebellion is inserted under 44th Constitutional Amendment Act of 1978. So, once the President is satisfied of the threat of security of India, either by war or external aggression or by armed rebellion, then he could proclaim an emergency, which is a national emergency under Article 352 of the Constitution under Clause 2, 1 of the article. And as per Clause 2, a proclamation issued under Clause 1 may be varied or revoked by a subsequent proclamation, and the proclamation as per the provisions of Clause 4 shall be laid before each house of the Parliament and shall accept where it is a proclamation revoking a previous proclamation, and as regarding that it has been approved by resolution of both houses of Parliament. So, as regarding this, and as the very provision of national emergency, as we found under Clause 5, a proclamation so approved shall, unless revoked, cease to operate on the expiration of a period of 6 months from the date of passing of the second of the resolutions approving the proclamation as provided under Clause 4. So, now we will discuss one important leading case relating to proclamation of national emergency, and in that regard we will discuss the rulings of the Supreme Court in Minerva Mills Limited versus Union of India in 1980. It was pronounced by the Supreme Court that neither Article 352 nor any other article of the Constitution contains any provision saying that a proclamation of emergency validly issued under Clause 1 shall cease to operate as soon as the circumstances warranting its issuance have ceased to exist. Hence, as long as the proclamation of emergency is not revoked by another proclamation, it would continue to be inoperative irrespective of change of circumstances, as it was pronounced by our apex court in Minerva Mills Limited versus Union of India. And now we'll discuss the very effect of proclamation of national emergency under Article 352. So the effects of proclamation, as we found under Article 353 relating to union executive power and union legislative power. So the very effect of proclamation of emergency under Article 352, the very fact that the executive power of the union shall extend to the giving of direction to any state as to the manner in which the executive power thereof to be exercised. So the union executive power would extend to the states. So under this, the union executive can give any direction to any state. As once the national emergency is proclaimed by the President of India under Article 352, so also another effect, as you found under Article 353, is regarding union parliaments or legislatures' power to make law with respect to any matter. Conferring such power or imposing duties or authorizing the conferring of powers. So the union legislative power, even if it is not enumerated in any list, so it would extend to any such label as it would be under the wish of the Parliament of India. And as regarding Article 354, which is dealing regarding distribution of revenues, so once there is the proclamation of an emergency under Article 352 is in operation, the President may or relating to any distribution of revenues as per Article 268 to 279 of the Constitution regarding distribution of revenues shall for such period not extending in any case beyond the expiration of the financial year in which such proclamation ceases to operate. So, in that regard also, the president have the exclusive power regarding distribution of revenues in between among the states as per the provisions of Article 268 to 279 now would be in the hand of the president during that financial year in which the national emergency is proclaimed by the President of India. So now we'll go to the provisions of Article 355 which deal the duty of the Union to protect states against external aggressions and internal disturbance. So, in that regard, we would like to discuss another important ruling of Supreme Court in the leading case X Armaments Protection Services Private Limited versus Union of India in 2014. The Supreme Court on the issue of determination of national interest pronounced what is the interest of national security is a matter of policy, so it is to be decided by the executive and not by the court, as it was pronounced by the Supreme Court. So now we'll go to another important emergency provision under Article 356, that is the President's rule. So, the President's rule in a state depends on the report of the governor to the President regarding the breakdown of the constitutional machinery in a state. So, whenever it is found the report of the governor sent to the president regarding that, and if it is the satisfaction of the president also that a situation has arisen in which the government of a state cannot be carried on in accordance with the provision of this constitution, as because the very constitutional machinery of a state has been broken down, or very failure of the constitutional machinery of a state. In that case, the president, if he is satisfied, then he can proclaim state emergency or president's rule under Article 356. And now we'll go to Article 357, which provides the exercise of legislative powers. So, as provided under Article 357 of the Constitution, whereby the proclamation issued under Clause 1 of Article 356, it has been declared that the powers of the legislation of the state shall be exercisable by or under the authority of Parliament. So, the Parliament of India now could exercise the very power of legislatures of the states to make laws. So, in regards to that, we would like to discuss the very important leading case, that is S.R. Bommai versus Union of India, which was first decided by the Karnataka High Court in 1990, and subsequently it was on an appeal before the Supreme Court in 1994. The Supreme Court pronounced certain propositions. So, in that particular leading case, those propositions of the Supreme Court judgment are that the presidential proclamation dissolving a state legislative assembly is subject to judicial review. And secondly, the burden lies on the government of India to prove that relevant material existed to justify the issue of proclamation. And further, court should not go into the correctness of the material. And so also, if the court strikes down the proclamation, it has power to restore the dismissed state government to office. And finally, a state government pursuing anti-secular politics is liable to action under Article 356 of the Constitution. So these propositions were made by the Supreme Court in its 1994 judgment in appeal. In this case, S.R. Bommai versus Union of India. And now we'll discuss another important ruling relating to the leading case, Rameshwar Prasad versus Union of India in 2006. So, in that particular leading case, the judgment as delivered by the Supreme Court, proclamation under Section 356 is open to judicial review only when the power is exercised, modified, or is based on wholly irrelevant ground. So now we'll go to the very provision of Article 358 regarding the position of Article 19. So there would be suspension of provisions of Article 19 during the emergencies as issued under. So the proclamation of emergency declaring that the security of India or any part of the territory thereof is threatened by war or by external aggression as in operation. Nothing in Article 19 shall restrict the power of the state as defined in Part 3 to make any law or to take any executive action which the state would be put for the provisions contained in that part be competent to make or to take, but any law so made shall, to the extent of the incompetence, is to have effect as soon as the proclamation ceases to, operate. So, as per the provisions of Article 358 as per constitutional provision, this is the position of Article 9 and now we'll discuss the provisions of Article 359 and enforcement of Part 3 of the Constitution. So, as regards the provisions of Article 359, there would be suspension of the enforcement of the rights conferred by Part 3, which deals with fundamental rights during the emergency, as provided under Article 359, and in relation to that, we would like to discuss the ruling of important judgment delivered in 1976 by the Supreme Court ADM Jabalpur versus Sipkant Shukla. So, in that particular leading case, the pronouncement is that by the Supreme Court, the bar created by Article 359 applies to petitions for enforcement of fundamental rights mentioned in the presidential order, whether by way of an application under Article 32 of the Constitution or by way of any application under Article 226 of the Constitution, respectively before the Supreme Court or the High Court's jurisdiction. So, in regards to that, the very pronouncement of the judgment of Supreme Court is relevant in context the operation of Article 359 regarding enforcement of Part 3, which constitutes the fundamental rights, as it was pronounced by the apex court in this important leading case, ADM Jabalpur versus Sip Council. So now we will briefly discuss the provision of Article 360, which is regarding proclamation of emergency. So, if the President is satisfied that a situation has arisen whereby the financial stability or credit of India or any part of the territory thereof is threatened, he may, by a proclamation, made a declaration to that effect. So, this is all about the emergency provisions as provided from Article 352 of the Constitution to Article 360 of the Constitution dealing with national emergency. Also, under Article 356, the President's rule, as per the report of the Governor regarding the failure to carry out the constitutional machinery in a state, or in regards to breakdown of constitutional machinery in a state. And also we have discussed the very extension of executive power and union legislative powers under the proclamation of national emergency. Also, the extension of legislative powers under President's rule, and also regarding the very position of Article 19, which deals with fundamental freedoms, and also the enforcement of Part 3 of the fundamental rights of the Constitution, with important leading cases. Now we'll discuss one of the most important provision regarding declaration of national emergency. Why the late Prime Minister of India, Mrs. Indira Gandhi, in 1975, which caused a sensation in the world, regarding which we have titled, it caused the death of democracy in India. So, in regards to that, we would like to discuss certain important incidents occurring during the proclamation of national emergency in 1975. So, exactly when Justice Jagmohan Lal Sinha, the Justice of Allahabad High Court, gave his ruling on 12 June 1975 and disqualified the late Prime Minister Mrs. Indira Gandhi from membership of either houses of parliament or of any state legislature for a period of 6 years, and also declared the election of her as invalid. So, the very article dealing with death of democracy started from the very ruling made by Justice Jagmohan Lal Sinha, who declared Mrs. Gandhi's election as invalid in his ruling on 12 June 1975 while delivering as a judge of Allahabad High Court. So, subsequently on 23rd June, Supreme Court allowed a conditional stay to the operation of the judgment of Allahabad High Court. So, on 23rd June, the Supreme Court, Justice V.K. Krishna Iyer heard the application of Mrs. Gandhi for an absolute stay order, which would allow her to retain both her seat in Parliament and the premiership until the Supreme Court had heard her appeal. On the following day, Justice V.K. Krishna Iyer granted her only a conditional stay, allowing her to retain the premiership and to address Parliament in that capacity, but not to vote in Parliament or to draw her salary as a member. He left it open to either party to go before a division bench to modify the order if there be any change of circumstances. He made it clear that he was not going into the merits of the judgment of Allahabad High Court and was dealing with the stay application only from the legal point of view without going into any political aspects. So, subsequently, the very judgment of conditional stay as issued by the then Supreme Court Justice V.K. Krishna Iyer created a storm in the political circle in India. So, many of the leaders like Raj Narayan, Madhu Limaya, Shamar Guha, Madhu Dandavati, S.K. Patil, S.N. Mishra, Pillu Modi, L.K. Advani, Mohan Daria, Charan Singh, and Jyoti Basu, even M.C. Chagla, a former minister of External Affairs who was a retired Chief Justice of the Bombay High Court, said on the very judgment of Justice V.K. Krishna Iyer of Supreme Court that no one should hold the high office of Prime Minister with a cloud over her head. Then he asked who has heard of a Prime Minister who cannot vote in Parliament of which she is a member, implying thereby that she should resign. Shanti Bhushan, the counsel for Raj Narayan, said that a crippled Prime Minister should now reconsider her earlier decision to stick to power. So, these are the developments which persuaded the Prime Minister of India. So, some of the inner circle of the then late Prime Minister, Mrs. Gandhi, went to the Rashtrapati Bhavan in the dead night of June 25 of 1965 and obtained the then late President Fakiruddin Ali Ahmad's signature on a proclamation that a grave emergency existed whereby the security of India was being threatened by internal disturbance. So, the national emergency under Article 352 was proclaimed by the then late President Fakiruddin Ali Ahmad on 25th June 1975, which led to country-wide arrest and detention. So, as per the declaration, the government of India started country-wide arrest and detention of the then important national leaders such as Jayaprakash Narayan, Morarji Desai, Raj Narayan, Charan Singh, Nanaji Deshmukh, George Fernandez, Pilu Modi, Ashok Mehta, Jyoti Basu, Atal Bihari Vajpayee, Samar Guha, and Biju Patnaik from Odisha. So, almost many such leaders were arrested and detained under the proclamation of national emergency by President of India under Article 352 of the Constitution. So many organizations were banned, such as the Rashtriya Swayamsevak Sangh, Jamaati Islami, and several factions of Anand Mark and the extreme left Naxalite functioning as Marxist Leninist were banned by four separate orders under Rule 33 1 of the Defense of India Rule 1971. So, also, there were amendments made to the Maintenance of Security Acts. So, the first such amendment was made by the President on the late night of 27 June, as by issuing an order under Article 359, Clause 1 of the Constitution, as regarding proclamation of emergency. So, there was an amendment to the Maintenance of Internal Security Act of 1971, and also there was an ordinance on 29 June inserting a new provision in the original Maintenance of Internal Security Act of 1971, whereby the amended provisions were to have effect only during the period of the operation of the proclamation of emergency, but not extending a period of 12 months. Also, another ordinance was issued by the President on 16 July 1975 to amend the Maintenance of Internal Security Act, and amending the ordinance had stipulated that detainees could not get any relief against the order of detention under rules of natural justice, and further that no grounds for the order were required to be supplied to them for a maximum period of 1 year. So, the very amended provisions as under Section 16A of the Maintenance of Security Act was Maintenance of Internal Security Act 1971 was amended in order to specifically render inoperative Section 8 to 12 of the original Act. These sections respectively had provided for disclosure of grounds of detention, constitution of advisory boards, reference to advisory boards, procedure for the conduct of advisory boards, and actions to be taken on the report of advisory boards. So persons detained under the amended Maintenance of Internal Security Act ordinance were made ineligible to any of these rights up to a maximum period of 1 year. A new feature of this ordinance was that foreigners also could be detained under the Maintenance of Internal Security Act, and they too could not claim any right to personal liberty by virtue of natural law or common law, if any. So, in this regard, we would like to discuss one of the important habeas corpus petition and the very ruling of the Supreme Court. So, in spite of repeated amendment of the Maintenance of Internal Security Act, in this particular important case relating to habeas corpus petition on 28th April 1976, the majority of 4 Supreme Court judges held as under in view of the presidential order dated 27 June 1975, no person had any locus standi for habeas corpus or any other writ or order or direction to challenge the legality of an order of detention on the ground that the order is not under or in compliance with the act or is illegal or is vitiated by malafide, factual or legal, or is based on irrelevant consideration. So Supreme Court held that Section 16A Clause 9 of the Maintenance of Internal Security Act is constitutionally valid. This section prohibited the disclosure of the grounds of detention and the next of the judgment. The appeals are accepted, the judgment of high courts are set aside, and the final pronouncement of the Supreme Court in this habeas corpus petition. Petitions before the High Courts are now to be disposed of in accordance with the law laid down in these appeals. So, in that period, during this period, there was a constitutional amendment which constitutes a great danger to the Constitution of India as it was amended under Act 39th Constitutional Amendment Act of 1975, which amended and inserted Article 329A, and as per the amendment insertion of Article 329A, now the very election of the President, the Prime Minister, Vice President, and the Speaker of Lok Sabha could not be called for in any court of law. So it was made beyond judicial review. So also Supreme Court in 7th November, as the very 5-judge bench headed by the then Chief Justice of India, Justice N. Roy, set aside Raj Narayan's cross appeal before the Supreme Court and upheld Mrs. Gandhi's election and reversed the very judgment delivered by Allahabad High Court. So, in between, as per the operation of national emergency as it was proclaimed on 25 June 1975, under the proclamation by 3 ordinances, there was press censorship in India. So, as per the very Rule 48 of the Defence and Internal Security Act of India, 1971, the newspapers were forbidden to publish inter alia reports which affected India's relations with foreign powers. So, these are the major developments which made under Mrs. Indira Gandhi's proclamation of national emergency on 25th June 1975, which we have discussed, which in fact led to the death of democracy during the period of June 1975 to up to March 1975, the period when the very national emergency was in operation, could be better titled as Death of Democracy in India. And finally, Mrs. Gandhi announced election to the new Lok Sabha. Why? The president dissolving the Lok Sabha or the House of People, and finally the election to the new Lok Sabha was held, and in consequence to that election in 1977 March, a new national government was formed by the then Janata Party under the leadership of the then late Prime Minister Morarji Bhai Desai. So we have concluded the constitutional provisions relating to emergency in India. So also the fact and the actual occurrence of the national emergency declared by the then late Prime Minister Mrs. Gandhi on 25th June 1975. So we have completed this lecture on emergency in India.